sexual assault, or that is a threat that reasonably places the member in fear of imminent physical harm, bodily injury, assault, or sexual assault. They say family violence means an act by a member of a family or household against another member of the family or household that is intended to result in physical harm, bodily injury, assault, or explanation. But there is no explanation for this. One, I think everyone knows you don't leave children in vehicles, no matter if you think you're going to be going in for 2 seconds or a minute. Number two, everyone knows, and I don't know what it is about Texas and other people loving their guns. You know, let me go to sleep with my gun. Fine. I'm fine with people owning guns, but if you're going to own weapons, you need to be responsible.
Judge, it's not her gun.
No, but here's the thing. Children are alone in a vehicle. There's a gun. Do you know there was just a news article where some toddler shot their brother in the head with a gun? That child is dead. And guess what? That toddler is never going to get over the fact that they killed their brother, whether or not it's their fault or not their fault. And it's really not their fault, because there is a reason. What did they tell us in law school? The reason why what is the term they use? The reason you had to have fencing around your pool. What kind of danger is that?
Did you invite that? Yeah.
No, it's question for deferred.
There is, Judge.
All right, the court is calling 2025 CR 011383 State versus Kendall Ortiz. Can I have parties announced?
Courtney Allensworth and Ashley Jones for the state.
Don Flannery for Miss Ortiz.
Are you Miss Ortiz?
Yes.
Counsel, you received all discovery. Did you review it with your client?
I have and I did.
Court will find that the state is in compliance with discovery. Miss Ortiz, did you review the application for community supervision and deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Proceeding on count one and waiving count two.
Any objection?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes.
All right, in count one, you're charged with abandoning and endangering a child, and placing the child in imminent danger of bodily injury as a second-degree felony. Range punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Ortiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 4 years in the prison. There's a $1,500 fine. State is silent on your application. They're asking for an affirmative finding of family violence.
That's correct.
That is correct, Your Honor. I believe the court will see from the facts.
All right, thank you.
Thank you, Judge.
Affirmative finding of family violence, you're not allowed to be designated a primary custodial parent, and you're not allowed to own or possess any weapons or ammunition. Did you understand that to be the entirety of your plea?
Yes.
Defense?
Yes.
State?
Yes.
Is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence
State Exhibit 1
No objections.
and attachment.
and attachments.
All right. Any objections?
No objections.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Is there any other criminal history with your client?
No, Your Honor.
All right, do you want to proceed with sentencing?
No, Your Honor, would like to do PSI.
Do you want to proceed with sentencing?
Today,
Yes.
we would like to do a PSI so that we can. let the
Do
court-
you want to proceed with sentencing today?
Your Honor, can we confer for just 1 moment?
Sure.
Thank you, Judge.
Your Honor, we're of the opinion that if we prepare a sentencing memorandum and we prepare for sentencing, the court will be most inclined.
Do you want to proceed with sentencing today?
No, Your Honor.
All right.
Yes, Your Honor.
Yes, to.
Proceeding the sentencing.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. Miss Ortiz is a mother of 3 children. When this occurred, she was pregnant, many, many months pregnant. She had 3 children in her car that she was taking to school. She's not a single mother, but she's a stay-at-home mom, obviously. When she went to the school, it wasn't the summertime, it wasn't hot outside. It wasn't the wintertime, it wasn't cold. It was probably 70 degrees. At the elementary school that her young child goes to, she has to run him in. She's got 2 youngsters sitting in the back seat.
But here's the thing, and I understand where you're going with your explanation, but there is no explanation for this. One, I think everyone knows you don't leave children in vehicles, no matter if you think you're going to be going in for 2 seconds or a minute. Number 2, everyone knows, and I don't know what it is about Texas and other people loving their guns. You know, let me go to sleep with my gun. Fine. I'm fine with people owning guns, but if you're going to own weapons, you need to be responsible.
Judge, it's not her gun.
No, but here's the thing. Children are alone in a vehicle. There's a gun. Do you know there was just a news article where some toddler shot their brother in the head with a gun? That child is dead. And guess what? That toddler is never going to get over the fact that they killed their brother, whether or not it's their fault or not their fault. And it's really not their fault, because there is a reason. What did they tell us in law school? The reason why what is the term they use? The reason you had to have fencing around your pool. What kind of danger is that?
Did you invite it? Yeah.
No, it's
It's a
something.
nuisance.
Oh, my God.
No.
Fighting the nuisance.
Defense attorneys. Thank you. It's an attractive nuisance. That's why you have to put a fence around it. And with regards to guns, what I've discovered in my time on this planet, no matter how often you tell children, this is not a toy, this is dangerous, they want to pick it up. I remember watching, what was her name? Kamora Lee Simmons. there was a clip, she was shopping for a home, right? And so there, she tells the realtor, I have little children and you're taking me out to a pool and there's an open fire, right? And she said, I know it's a fire, it's hot, but I want to put my hand in it because this just seems like there's water running over the fire. Let me touch it. So your child could have been killed, or either they could have ended up killing someone else. And if they would have killed someone else, you would have been charged with that. If they would have killed their sibling who was in the car, you would have been charged with that. And guess what? That toddler would never have been able to get over that. Even if they were able to black it out and their psyche is protecting them, at some point it would come up at some reunion or something that at one point they had a sibling. Do you understand?
Yes.
Judge, there's something that the court needs to be aware of.
Yes.
So she didn't know the gun was in there. Her husband left the gun in there, unbeknownst to her. Now, obviously, she shouldn't be leaving the kids alone because these are the sorts of things that can happen.
Mhm.
When she found out, she was mortified. She immediately, she almost went into labor, had to go to the hospital for several days. She had no knowledge that the gun was in
Where
there.
are the children?
Now, do what?
Where are the children?
Where are they now?
Yeah.
They're with their babysitters right now.
Okay. And was Child Protective Services called? Because
Absolutely.
usually they are.
Absolutely.
So
They
what
were-
is the result of Protective Services?
They told me it was an isolated incident
Yeah,
and they're
She's
safe
had
at
her
home.
children returned.
I com-
So they fully investigated all of this. And
All right, so this is what I want you to understand. And I hear your attorney's argument and I appreciate his arguments because he has to represent you, but I'm trying to instill in you that at any second from something we did or didn't do, children can be taken away by CPS or because there's some danger. And based upon what I read, if you would have ran into a grocery store, right? And nobody, you were not parked in line and no other parents came, because the only reason why your child dropped that weapon and hopped over in the back seat is because another parent came to see what was going on. And then game over. And then you would have been devastated. Your child would have been devastated and you would have lost the child. You can't be doing that. And I can tell you right now, I'm going to order that you have no weapons in your home.
absolutely. Well, and that's why we insisted to have the affirmative finding of family violence, so that for the rest of her life, she can't have a firearm. Even if you give her deferred and she's not a felon, she can never own a firearm, because we don't want the husband to think, well, I can have a firearm, because none in the home. So that was a big sticking point on our point, because we wanted to make sure, because ultimately this is her husband's fault. Now, he wasn't charged, he's not culpable. They've dealt with that and they've dealt with him. He's obviously very upset about this, but I'm mad because it's his fault that she's in this position. But then again, she should never have left the kids in the parking lot.
Yeah.
And that's why we're here. But I think with the affirmative finding that we came up with, it's a way that you can ensure she can never have a gun, and more importantly, that husband can never have a gun in that home, because that's the most important thing.
And the other issue, when you leave children alone unattended, a stranger can come up and take your children.
Anything
I don't
can
know
happen.
why in San Antonio, people think that, oh, I'm just going to let my child run around. That is why I really don't go to the mall. You know why? Because I end up having to watch other people's children because they're letting them walk behind them. And then it's like I'm a stalker trying to make sure this child is not lost. All right. Probation, are you ready? I'm ready, Judge. This is what the court is going to do. Count one. The court is going to sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs or the patch. Are you employed or stay at home?
I stay at home, but I am a part of the San Antonio Ready to Work program.
All right, proof of employment within 45 days, no employment as a home health care provider or with minors. There's a $1,500 fine, time and money to run concurrently. All right, with regards to this affirmative finding of family violence, how are you all saying that this is an affirmative finding of family violence?
Your Honor, was trying to look it up, but the internet is down. I was trying to get the exact wording for you.
Because I'm trying to see the connection. Because I mean, either way, I'm
Well-
gonna order that she not have any weapons.
Right, well,
I mean, that would
The
be
reason would
sufficient,
be-
Your Honor.
logically, is that, and I'm not usually the one to argue in this position, but I do believe that it's helpful, is that the child is named as a victim in the indictment. Now statutorily, if that doesn't do it and the
So-
court isn't inclined, I understand that as well.
Just from my memory of the statute, and I am trying to find it in the book here, it placed the child in a risk of for bodily injury, which by statute, I believe, is sufficient. If you'll just give me one moment to find that, Judge.
Okay, so let me see.
130. Is it 71?
It's 42.013.
Yes, but you have to look at 7101, I'm sorry, 71004 of the Family Code, Your Honor, which I
Yes.
don't have access to at the moment in this book.
Well, let me see if it's in there.
Okay. I should be looking now if there's.
Well, their thing of family violence and what it means. They say family violence means an act by a member of a family or household against another member of the family or household that is intended to result in physical harm, bodily injury, assault, or sexual assault, or that is a threat that
And
reasonably places the member in fear of imminent physical harm, bodily injury, assault, or sexual assault.
so that's kind of where we were going with it, Your Honor, but if the court doesn't agree, I mean, it's the court's finding.
I mean, if
so-
y'all want to
Well,
file a motion and say that I'm incorrect, I will of course review it, but based upon my reading of the code, this is not an affirmative finding of family violence. So this is what I'm gonna do. 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs or the patch, proof of employment within 45 days, no employment as a home health care provider or minors, $1,500 fine, time and money to run concurrent. You all agreed on a affirmative finding of family violence, but my reading of the law and my reading of the fact pattern, the facts that y'all have, it's not an affirmative finding of family violence. So if that is what you all consider to be not following your plea bargain agreement, now's the time to let the court know.
No, Your Honor.
no, Your Honor.
All right. There's to be no possession of firearms or ammunition. There's to be no firearms or ammunition in the household. There is to be 200 hours of community service restitution. 100 hours will be deducted. I'm going to require parenting classes. The other 100 hours will be deducted upon completion of a gun safety course. There is to be field visits 1 time per month for 8 months. Compliance with CPS if applicable. Probation, anything else? Anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I cannot stress enough to you what could have ended up happening. And it wouldn't have been good for you or anyone else. It wouldn't have been good for the people who would have had to come on the scene to address that. People who have weapons need to fully secure those weapons. And anything that you have around your household that is attractive nuisance needs to be secured.
Yes, ma'am.
That is another reason why when you have cleaning supplies, people say lock those from toddlers. When they start crawling, they get into everything. They put everything in their mouths. Okay?
Yes, ma'am.
All right. Once you speak with probation, get your conditions, make sure you stay in contact with them.
Okay,
Oh, just 1 second. Yeah, I did do 4 years deferred. All right. Good luck to you.
thank you.
Thank you.
Judge.
All right. This is the PSI.
Yes,
Attorneys, when you approach the clerk, you need to let them know the reason for your approach. So they'll know what documents I need. You don't have to file stamp it. That's okay. All right, the court is calling 2025 CR 0085561, State versus Veronica Callahan. Can I have parties announced?
Lauren Espinoza for the state.
Matthew Allen for Miss Callahan.
And are you Miss Callahan?
Yes, ma'am.
All right. You entered a plea on January 27th. According to your plea, the state was proceeding on count 1, waiving the enhancements. Punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine. The state is opposed to your application. They're taking in consideration 2025 CR 014278. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Yes, Your Honor.
Are there any objections?
None from the state, Your Honor.
No, Your Honor.
Any objections to the court reviewing the PSI and TAP evaluation?
No, Your Honor.
No, Judge, sorry.
All right, and state you're opposed. Do you have any witnesses?
No, Your Honor, just briefly.
Defense, do you have any witnesses?
No, Your Honor. Just argument as well.
Right, just give me a moment. All right. State, you may proceed.
Your Honor, we ask that you deny Ms. Callahan's applications and sentence to a cap of 6 years in the prison. Ms. Callahan has criminal history. She's been convicted of 2 DWIs, a manufacture and delivery of a controlled substance, PG1, as well as the possession of a controlled substance, PG1 4 to 200 grams, as well as another possession in 2016. Of these cases, she's been granted probation in 4 of these, 3 of which she was granted probation resulted in motions to revoke and sentencing either into the respective Bear County Jail or TDC. Ms. Callahan has been given chances on these probations and ultimately cannot comport her behavior to comply with the rules and conditions laid out before her. Based on the PSI and TAP, Ms. Callahan's in the pre-contemplation stage. We can see her when she recounts the facts of this underlying case. She essentially blames the officer. She said that she drove away because he reached his hand inside of her vehicle without providing a reason for the stop. However, she was afforded that explanation that it was because of expired registration. It was only because of her action of not cooperating with turning over her ID and identifying herself that the officer attempted to open the door to assist her out of the vehicle for non-compliance. She then drove off, and it was only after her vehicle was spiked, the rear tires had blown out, and there were multiple patrol units following, both marked and unmarked, that Miss Callahan stopped. Once she stopped, she still did not comply. She refused to get out of the vehicle and had to be assisted out by officers. Your Honor, Miss Callahan alleges that she has ceased majority of her drug usage throughout her life. However, I think it's perplexing that she expects the court or asks the court to believe that she has no usage. She merely just possesses narcotics. So because of these reasons, Judge, we'd ask that you deny her applications and sentence to a cap of 6 years.
Yes, Your Honor. The criminal history is what it is. So she was on parole. She completed that. As far as the instant offense, it's not a drug case. It's an evading arrest case. Her recitation of the facts are just that. It's a recitation. It doesn't say I'm not guilty of evading arrest because the officer reached into the vehicle. It's just her recounting what happened. Obviously, she's here because she's taking responsibility. She called the police even when she was driving, and we've had multiple conversations. 1, you can't take off when a police officer is there. 2, if you did, when you call the police and there's multiple other officers there, you pull off to the side of the road. You don't get to choose where you stop. And she understands that. She understands that, takes responsibility. That's why she's here today. She's not saying I didn't evade arrest or that there was some legal reason why I was able to not comply with the officer's commands. And that's why she's here, because she took a plea to accept responsibility. Since she's been out now, as far as the PSI goes, it says here current address. She actually does now have a stable address here in San Antonio, Texas. So she's not homeless, which helps with obviously trying
Why
to.
didn't you pull over?
The reason she didn't pull over is because she didn't feel that the officer explained anything. She thought she just got pulled over, and then he was reaching his hands into the vehicle. She felt unsafe. That's why she left and called the police herself.
So why did they have to put spikes down?
Again, that's because she was then trying to say, well, she was going to feel safe if she went to her house. So she's not driving at a high rate of speed, but we've had that conversation before. And so something from probation would be like a cognitive course, and thinking and critical decision making, because obviously that's an error in judgment. And that's a mistake. That's why she's here. As far as she does have a stable home, she actually has 2 jobs. One is a home healthcare worker, and I know the court sometimes does not allow people, but she has another job where she helps remodel a business for a man named James. She provided a letter from him to probation as well. So we have talked about this court and home healthcare working, and that's why she has another job set up and is already working that. Like I said, her housing, she actually had a trailer where she paid an individual $4,000 to live there. Well, that individual is not there any longer, and his wife is not agreeing with that. So she lost out on that money, but again, she's found other places. Mental health, she had been diagnosed a long time ago with manic depressant and bipolar. Again, she is working. She has support here. Paul Dickens is here in the courtroom, and he shows up. She showed up to court yesterday because she's heard this court say, do not show up late. She showed up a day early. She takes this case seriously. I don't see how sending her to prison sends any message or helps anybody. Again, she can take drug tests, she can work, she has housing, she can take a cognitive course, she can do a mental health evaluation. She even explained about that some of these things during the interview, she was crying because it was bringing up past things. And so she tried to be open and honest about it, about her past. And so again, they cognitive behavioral therapy. Again, there's some adverse childhood experiences. She has had a pretty good childhood. I just think that the court can put conditions in place that allows Miss Callahan to continue to support herself, get better, and protect the community all at once. And so we're asking this court to give Miss Callahan just an opportunity to go on probation. Understand she had been on probation a while back and didn't take advantage of that. But she is a different individual here today. She wants to take responsibility. She does want to show the court and herself and her support system that she can follow this court's orders.
May I answer the question
About
the reason of,
Do y'all need to step back?
well, when that's the child, his supervisor. The reason being was that he was.
Yeah, so she had conversations with the supervisor of SAPD about the interaction and some of the ways that were done. And so, but again, that's after the fact. That doesn't absolve her from it, but she has tried to take responsibility, examine herself and her responsibility in that situation. And obviously she was wrong, and that's why she's here today.
State?
Your Honor, I would just ask the court to deny applications. Ms. Callahan when asked how supervision would help her first statement was, it would definitely help me so I don't lose my freedom. I think that's what is exhibited here. Ms. Callahan thinks her freedom is more important than the law. She thinks that she can flee because she feels unsafe. And at what point are we to show Ms. Callahan that you must comport and comply, and you can't keep running from things because you think you're right? So I don't believe she would be a good applicant or candidate for any sort of probation judge. And while this court may and will probably be able to accommodate and target some of the issues Ms. Callahan experiences, I don't think she is deserving of that chance because she's shown she cannot comply.
All right. Anything you wish to say? I mean, if you want to say something, then I'll have to put you under oath. State will have a chance to ask questions.
I just know that.
All right, no.
No,
Do you want,
I don't want to.
Okay, no, Your Honor.
you're sure? Ms. Callahan, what I'm telling you, if there's something you want to say to me, then what I have to do is I have to swear you in. And then I will listen to whatever you want to say to me, but the state will have an opportunity to ask you questions as well. So do you need to speak with her concerning that, counsel?
No, Your Honor, we've spoken about it. And no, she doesn't wish to talk other than what I've explained and what she's said.
All right, Ms. Callahan, I reviewed the PSI, the TAP evaluation. I've listened to your attorney and listened to the state. I just don't think you're a good candidate for probation. Okay. I'm going to find you guilty, taking consideration 2025 CR 014278. There's a $1,200 fine, time and money run concurrent. I request the therapeutic community, and I'll sentence you to 3 years in the prison and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Right to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed. State versus Julian Teo Jr. Can I have parties announced?
Brandon Prada for the state.
Good morning, Judge. Alfonso Cabañas for the defendant, Julian Tello Jr.
And are you Ms. Teo, Mr. Teo?
Yes, ma'am. Yes, Your Honor.
All right. Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Chao, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented
We are, Judge.
on both counts?
Oh, I'm sorry, Judge. We'll be waiving count one, we'll be waiving count one, proceeding on count two.
Any objection?
No objection, Your Honor.
And counsel, is this an application for deferred adjudication as well or no?
No, just regular probation.
All right. Mr. Teo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
In count two, you're charged with possession of a controlled substance penalty group 1B, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against
I
him?
believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Teo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count two. They're asking that your punishment be assessed at 5 years in the prison. There's a $1,000 fine probated, and they're recommending community supervision. Did you understand that to be your plea?
Yes, Your Honor.
State defense, is that the plea?
It is, Judge.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 100 hours community service restitution, the DOEP course, and MRT. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, Your Honor.
Then to count two, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Judge will offer state exhibit number one, including all attachments.
No objection to state one and attachments, Your Honor.
State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulations. Court will accept in the evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just ask the court to follow the plea agreement with the state, Your Honor.
All right, are you employed?
I was recently hired, Your Honor.
All right, what do you do?
I'm a remote customer service representative.
All right, do you have any children?
No, I don't.
And if you're drug tested today, what are the results going to be?
Negative, Your Honor.
When's the last time you used?
Probably June, I want to say, almost a year ago. I've been on probation from a different offense out of Denton County. So I've been doing a drug test, for that probation.
And what are you on probation for in Denton County?
It was for possession of controlled substance, THC, a prescription that I had out of Oklahoma.
Okay. And are you still on probation out of Denton County?
Yes,
All right, how long are you on probation there?
until June of next year.
All right, and what are your conditions there?
In a chilling courtroom moment, the victim finally speaks out, and her words hit harder than any sentence. She describes years of trauma, manipulation, and emotional abuse that shattered her life. From PTSD and anxiety to suicidal thoughts, the damage runs deep. But today she stands strong, no longer afraid. Looking directly at the defendant, she delivers a brutal truth. I still hate you, and you belong in prison. The courtroom falls silent as pain turns into power. This isn't just testimony, it's survival, justice, and a voice that refuses to be silenced. And this time, the world is listening.